Dominique. I am a second-year associate going into my third year, and at trial I did a lot. So I did a lot of motion drafting, getting everything organized for trial, along with...
My name is Sally. I'm a paralegal here at Sully Law Firm, and during the trial I did a lot of exhibit preparation, mainly helped all the attorneys keep their sanity together.
I'm Darren Singa. I'm the managing attorney here at the firm, and I was lead counsel in this litigation, which meant basically I asked the questions, did the opening and the closing. So when someone says a case is going to trial, what they really mean is that there are factual issues yet to be determined by the court and by the jury. Depends on which kind of case. In a big case like this, when it's a federal case, it will be a jury making factual determinations. So fundamentally, when you say you're going to trial, what you mean is you're presenting the facts to the jury. This trial was the culmination of a long, multi-year dispute between the parties. They were fundamentally in disagreement about branding of hair braids, but the truth is, with fashion, when you're talking about something like fashion, the branding and the recognition of the name is critical. The parties had been at each other for, I would say, 3 or 4 years. They thought they had this matter settled on multiple occasions, but still, there was a fundamental disagreement. This case was fundamentally about trademark rights. Our client had a registration for a valuable mark. The other side was at one point a licensee, meaning they had an agreement allowing them to use our brand, our name, on certain conditions. At some point, the other side had stopped complying with the requirements of that license. In other words, our client took that right away from them. We showed at trial that the other side, despite the taking away of that right, kept using the brand and kept using it in connection with goods that were confusingly similar to the goods our client was selling. Fundamentally, this case came down to enforcement of an older judgment by the court and rights under the Lanham Act, which is the federal trademark statute. This case fundamentally turned, I believe, on preparation. I think within the first hour of the trial, if you include the selection of the jury, opening arguments, and perhaps the first few questions of the first witness, I think they'd made a pretty strong preliminary decision. And a lot of that had to do with preparation. Between ourselves and the clients, a lot of intellectual property cases can get very technical, very hard to follow, and they can seem like somebody else's problem. But we worked very hard to present this case in a way that 12 ordinary Texans can understand that these rights are important and that the arguments we were making had validity. This trial went our way, and I think it's really helped our client. Sully Law Firm has represented this company for many years, not just in this litigation, but also in protecting their brand, generally speaking. They have multiple brands, and we've been working closely with them to protect those brands.
Preparing for this trial was definitely something that took me out of my comfort zone. I had to have a lot of discipline to be able to stay in the zone, to do trial prep for a month at a time. And about a week before the trial, we had all stayed late in the office. I think we were working 70 to 80 hours that week. It required a lot of discipline and a lot of self-control to continue to be able to prepare for this trial, which could be a life-turning moment for our clients. And especially with our team, we had a lot of internal communication, which allowed us to better our understanding of the case itself, as well as our client's position, putting us all in the very same space, like the headspace to move forward successfully in this litigation.
So I started my preparation for trial very, very early. I think I started getting things together in March and trial was scheduled in July. So it really was just a matter of staying on top of all of the documents, discovery produced, keeping track of the elements and what exactly we were going to use to prove each element of our claim. And so it was a lot more streamlined when we got closer to trial. It was just easy for us to say like, hey, I have this spreadsheet. It has all the elements. I linked all the documents here. You can pull this here and put it in this folder. So we, I think, did a great job of like keeping everything organized and being very well prepared and presentable for trial.
I think one of the biggest thing was because our clients were Korean speaking and English wasn't their native language, there was always some sort of a language barrier between our team and the client, and of course, having multiple Korean-speaking attorneys, paralegals, and staff here, it was really difficult for us to relay the message. I had to translate everything from English to Korean, and then I had to translate some more words which they didn't understand, and that itself was a pretty significant challenge. But at the end of the day, our clients were very attentive. They were very hands-on on the case itself, and we were able to get them to successfully prepare for the trial.
It was my first time being first chair on a trial in my experience as an attorney, and so I got to see kind of up close how you can present yourself to a jury and relate to a jury and talk to them in a way where they kind of understand the legal issues that are going on. And so I thought that that was particularly memorable.
I remember when Darren and Dominique came out of the chambers. I couldn't read their faces. I was nervous, the clients were nervous. And when they finally told me, I was shaking. I was like, oh my God, oh my God, oh my God, this happened, we did this. And just being able to tell the client what happened, that they had like won all the verdicts with the jury. It was just an amazing moment, and I knew that the clients were overwhelmingly happy, and I think we were all just really happy for them.